associations, and all the people who've supported this program. I have heard very good things from some of my friends about this program, about the way it's been going, because I believe it's got more than 500 participants. It's being streamed on YouTube. There's been a lot of enthusiasm. And I think Parth mentioned to me earlier this afternoon that YouTube has about 1,000 views. So I'm very happy to start this right now. But as I do that, I am going to get up from my chair because unlike all your other panelists, I don't have a single slide to share with you, which basically means that you will have to hear me out if you decide to go through this entire 1 hour. And two, it will all have to be done by way of question answers at the end of the session. So let me begin as I would customarily begin any other lecture or that I was giving either in a conference or I also teach or to people I teach. And I would begin by saying, good evening, ladies and gentlemen. And I would then start telling you, I am sure that all of you have had enough of one, COVID-19, two, of the lockdown and its effects, three, about the talk when this lockdown is going to be lifted, and four, of all these webinars that are being organized. And if I make any reference to any of those discussions, I am reasonably certain that I will bore you to death. So let me first of all thank all of you for attending yet another webinar. And I will promise you that I will not talk about any of these so that you are not bored to death. The other thing that I'm reasonably certain all of us have been doing over the last 3 or 4 weeks has been watching every available movie on Netflix or on Prime Video, and for any sports enthusiast, the replay of their old favorite movies. I mean, let me tell you, I have watched that movie on Sachin Tendulkar for the 6th time in the last 15 days because my 5-year-old son insists on watching it and insists that he wants to be the next Sachin. I mean, we all live in this aspirational country, but frankly, I am completely bored out of my wits watching movies. So what really gets me to really wonder is how a lecture in law can lift you out of the miseries that we are all faced with today. And even if a lecture in law does make you get out of those miseries, how does a lecture in constitutional law do that? And to that extent, I agree with Anshin, this is an extremely difficult topic, not for any other reason, but because I will tell you very honestly, when I studied constitutional law as an LLB student in India, it was in fact the most boring subject that I had ever been asked to study. And it wasn't until I started practicing before the Supreme Court in the early part of my career that I started realizing how exciting constitutional law was. Because when you start eating, sleeping, and breathing the Constitution, because you end up invoking one or the other article of the Constitution on a daily basis in order to be able to act for your client, you realize how powerful the Constitution of India is. It is, as its preamble suggests, a document which is by the people. You've got the word we the people, and it's for the people, and it secures them for things. 1, justice. 2, liberty. 3, equality. 4, fraternity. And it is within the framework of these basic contours, which take the nature and the color of what is called basic structure. And I'm sure a lot of you remember the big decision in case Vanan Bharti, that the Constitution of India protects rights. Now, for today's lecture, I don't propose to talk to you or take you through the entire Constitution. I mean, I think that would be impossible given the time that we have. And I also think it would be exceptionally boring if I started taking you through article by article. What I do propose to do is to actually frame this by bearing in mind, by framing this as topics and subtopics, and I will take you through that. And my focus on the Constitution of India in relation to commerce and commercialism is going to be on the protections that it offers or the lack of protections that are there in these matters. And it is very possible as I go through this lecture that I will miss out a couple of judgments which you may consider to be extremely relevant, but frankly, we do have limited time. How else and how best do you start off with the Constitution? Well, the best way to start off with the Constitution is to look at the apex body which protects it. And that is the Supreme Court of India. And how best do you look at the Supreme Court of India? You look at the Supreme Court of India from the perspective of its history. And so let's look at the Supreme Court of India from its historical perspective. And I am going to quote to you from a book which is called The Supreme Court of India, The Beginnings, which was released in 2017 by a noted author called George H. Gadboy. And he writes, by quoting certain other authors, that the jurisdiction of the Supreme Court is so wide that it will appear to be the most potent judicial organ in the world today. Now, while Gadboy accepts that in theory, the Supreme Court has extensive powers, which is based on the articles that it has, he makes a very relevant point. He says, but the Supreme Court is not as powerful as certain other courts. And he cites two examples to be able to get there. One of those examples that he refers to relates to the power of Parliament in vitiating decisions of the Supreme Court by either amending the Constitution or even statutes. Now, what does all this have to do with commerce? Let me give you an example of a really major decision that was taken by the Supreme Court. This relates to the 2011 decision in the Vodafone case, which related to an advance tax claim which has been levied by the Union of India against Vodafone International for 11,000 crores, which would in effect have meant a potential liability, tax liability of 33,000 crores. And this is probably one of the largest tax cases that ever went and got litigated. And the Supreme Court struck down that levy. But that didn't end there. The Parliament amended the Income Tax Act. And the effect of that decision of Parliament was to nullify the judgment of the Supreme Court. The second decision on this point relates to the 2020 decision of the Supreme Court, which Anshan made a short reference to when he was introducing me, and that was relates to Hindustan Construction. And I will deal with that a little later. But the reason why I make this point right now is this, because in that case, after an amendment that had been brought in to nullify the effect of a Supreme Court judgment, the Supreme Court struck back and nullified the amendment. So you will always see in the history of the Supreme Court of India a toss between Parliament and the Supreme Court. And this brings me back to Gadboy, because what he says in relation to the powers, and which I completely agree with, and I will quote, is the following. In fact, courts in India have long enjoyed a vast amount of prestige and confidence amongst the public. The high courts, some dating back nearly a century prior to independence, and the federal court had established an enviable record of integrity and independence. Thus, when it came to deciding upon the jurisdiction of India's Supreme Tribunal, endowing it with extensive jurisdiction was seen by most as both wise and desirable. And I could not agree more. And I am sure that whoever has followed the history of governance in India ever since independence and juxtaposed that with the role played by the courts in either judicially reviewing administrative actions or determining the constitutionality of steps taken by various governments over the last 73 years, would accept that the Supreme Court has acted as a sheet anchor for India's democracy on a number of occasions. And the reason why all of this becomes relevant to commerce and commercialism, which I will deal with separately, is because commerce needs a level of stability. And the Supreme Court brings that. So let me now go into the broad topics that I propose to discuss in today's lecture. And I'm going to break this into 5 separate topics. Topic 1, I want to talk about the concept of federalism and free trade in commerce throughout India. Topic 2, I want to talk about commerce in the light of arbitrariness. Topic 3, I want to talk about commerce in the light of proportionate restrictions. And in that, I will touch upon Article 19(1)(g). Topic 4, I want to deal with private contracts and constitutional protections. And here I will make a reference to some interesting facets which govern practically every individual's real life today. And I want to make a reference to WhatsApp, which I know has been in the big news right now because of Facebook's recent acquisition of Reliance Jio for 43,000 crores. And I'm sure we will see a lot of that in India and how that's going to develop in the next couple of years. And topic 5, I will finally conclude with Constitution and its impact on commercialism. And just so that we get all of this correct, And so that we're all on the same page, let me just tell you the distinction that I draw between commerce and commercialism. And I'm going to pick this up from a dictionary meaning. Commerce is the activity involved in buying and selling of things. I think all of us understand that. Commercialism, on the other hand, is the principles and activities of commerce, especially those concerned with profit rather than quality or doing good. So in short, the difference between commercialism and commerce is that commercialism is commerce at any cost with only a profit motive in mind. And I think that's the distinction that I draw, and that's the distinction I will touch upon when I look at topic 5. So let's move on to topic 1, which is federalism and the freedom of trade and commerce throughout India. And when you look at the Constitution of India, you don't find this concept anywhere right in the first couple of chapters of the first couple of parts of the Constitution of India. You actually find this in chapter 13 under the head of trade, commerce, and intercourse within the territory of India. And what is critical here is Article 301 of the Constitution, which I will read out for your benefit. And it says freedom of trade, commerce, and intercourse. And it says, subject to the other provisions of this part, trade, commerce, and intercourse throughout the territory of India shall be free. Now, what is interesting is that Article 301 was taken from Section 92 of the Australian Constitution of 1900, which in its relevant part said trade within Commonwealth to be free on the imposition of uniform duties of customs, trade, commerce, and intercourse amongst the states, whether by means of internal carriage or ocean navigation, shall be absolutely free. Now, while the concept of free trade, commerce, and intercourse throughout the territory of India was taken from the Australian Constitution, the reality is that there was really no similarity between the provision in Australia and India, because when you put everything in together, the Indian Constitution was very different. And that is why in a famous decision, which I will again refer to a little later, called Automobile Transport versus the state of Rajasthan, Justice Hidayatullah wrote a very interesting dissent. And he said in his dissent that indeed, and this is a reference he was making to the Australian Constitution and the Indian Constitution, he said, indeed, they differ in so many respects that nothing is more dangerous than to suppose that the Indian Constitution wished to secure freedom of trade, commerce, and intercourse in the same way as the Australian Commonwealth. Several independent units joined together in Australia to form a federation to evolve a union government. In India, the transition was from a highly centralized government to a federation of states which were made autonomous units. And the best example of this in relation to trade and commerce that you get are from the entry tax cases. And to get there, let me just make a short 30-second interlude to some other parts of the Constitution, which are very well known to practicing lawyers, but I understand that there are some law students who are hearing this. So for 30 seconds, I'm going to address them on this, and that is India's quasi-federal structure. And in India's quasi-federal structure, you've got Articles 245 and 246, which grant Parliament the power to make laws for India and for the state to make laws for the state. And these are all in terms of what has been set out in the 7th schedule. And the 7th schedule has a breakdown of entries, which are in 3 lists called the union list, the state list, and the concurrent list. And one of those entries, which is entry 52 of the state list, empowers the state to impose entry tax. And when you read that with Article 304A, which I know I haven't read out to you, but I'll do it now, it effectively gives the state the power to tax. And I'm just going to read out the relevant part to you. It says, notwithstanding anything in Article 301, the legislature of the state may by law impose on goods imported from other states or union territories any tax to which similar goods manufactured or produced in the state are subject, so however, as to not discriminate between goods so imported and goods so manufactured and produced. So what is entry tax? For those who are not aware, well, it's something very simple. I manufacture, hypothetically, shoes in Maharashtra, and I want to sell them in Gujarat. Okay, and Maharashtra gives me a tax concession in relation to the manufacture of shoes, but Gujarat doesn't. So what Gujarat can do is to impose an entry tax on those shoes so that it protects its own shoe industry and to make sure that the local shoe manufacturers don't lose out to the shoes that come from Maharashtra. Now, states started imposing an entry tax the minute the constitution came in, and that led to a petition very early on in the Supreme Court called Atyabari Tea Company, which was in 1961. And the Supreme Court came out with a very interesting facet, which I'm going to explain to you, from which I'm going to quote right now, and it's going to form one of the aspects of how I conclude this section. And it said the following in Atyabari. And in Atyabari, the court said, in drafting the relevant articles of Part 13, the makers of the Constitution were fully conscious that economic unity was absolutely essential for the stability and progress of the federal policy, which has been adopted by the Constitution for the governance of the country. Political freedom, which has been won, and political unity, which has been accomplished by the Constitution, had to be sustained and strengthened by the bond of economic unity. It was realized in the course of time, different political parties believing in different economic theories or ideologies may come in power and in several constituent units of the Union, and that may conceivably give rise to local and regional pulls and pressures in economic matters. Local or regional fears or apprehensions raised by local or regional problems may persuade the state legislature to adopt remedial measures intended solely for the protection of regional interests without due regard to their effect on the economy of the nation as a whole. And let me pause here, because that analysis, which was done in 1961, I think has proved to be absolutely true. Today, when you look at politics in India, you look at regional politics, you look at regional interests, and all those interests seem to supersede the national interest, at least as far as economic policy is concerned. And let me just carry on with this quotation. It says, the object of Part 13 was to avoid such a possibility. The provisions contained in Article 301 guaranteeing the freedom of trade, commerce, and intercourse embodies and enshrines a principle of paramount importance that the economic unity of the country will provide the main sustaining force for the stability and progress of the political and cultural unity of the country. Now, we all know that Atyabari was partially set aside just a year later by a larger decision of the Supreme Court in automobile transportation. I'd made a reference to Justice Hidayatullah's dissenting judgment a short while ago. But it wasn't set aside in its entirety. And what automobile did was the following. It took the position that entry tax was not hit by Article 301, as long as it was a compensatory tax. And if it was a compensatory tax, then it would not be violative of the Constitution of India. And that brought in a new concept, the concept of compensatory taxation. And the reason why that is relevant is because it then brings out a larger concept on which you understand tax law in India. And the larger concept is that do taxes operate as a restriction or a restraint on business? Well, colloquially, the answer is yes. I mean, if we were a tax-free country, look at how much more liquid money all of us would have as individuals, as all of us would have as corporate houses. But the Supreme Court didn't agree. And they didn't agree, not in Atyabari, not in automobile, but 40 years later. All these judgments then finally led to a 9-judge bench decision of the Supreme Court in Jindal Steel versus the Union of India. And this is a decision which came out a couple of years ago, and they made 7 points. 1, they took the view that taxes simpliciter were not even within the contemplation of Part 13 of the Constitution of India, which basically means that the only chapter which dealt with trade and commerce in the Constitution of India, according to the Supreme Court, did not involve taxation. And they said that the word free under Article 301, which I read out to you, did not mean free from taxation. So trade had to be free throughout India, but it didn't mean it had to be free from taxation. And let me just give you a little quote from there. They said, once taxes are held to be outside of Part 13, for the reason that we've already stated earlier, there is no way that you can bring them into that part. 2, they said only taxes which were discriminatory in nature were prohibited by Article 304, subclause A, which I again read out to you. They then decided that it was high time they rejected this entire doctrine of compensatory taxes because they said it had no juristic basis. And once they did that, they then came and formulated the position which said that the taxes are not a restriction on trade. And I'm going to quote from what the Supreme Court said, and it said, in light of what we've said above, we answer question number 1 in the negative and declare that a non-discriminatory tax does not per se constitute a restriction on the right to free trade, commerce, and intercourse guaranteed under Article 301. Decisions taking a contrary view in Atyabari, followed by a series of decisions later, thereafter stand overruled, including the decision in automobile transport, declaring that taxes generally are restrictions on the freedom of trade, commerce, and intercourse, but such of them as are compensatory in nature do not offend 301. And that's the concept that you have today under commercial law and taxation in India. And then they went ahead and brought a new concept, at least in relation to entry tax. And what they said was this: they said a tax on the entry of goods into the local area for use, sale, and consumption therein was also permissible, although similar goods were not produced within the taxing state. Now, I gave you that example about the shoes, because that's what 301 and 304 were supposed to protect. And that's what people understood. But the Supreme Court went a step further and said, well, that's not correct. It doesn't matter whether or not those goods are produced in India. And the reason and the logic for that was, they said there was no discrimination if the goods were not even manufactured in the state. And I'll just read out again from the Supreme Court's decision. They said, the essence of guarantees in Article 304A lies in the same or similar goods being treated similarly in the matters of taxation. The question, therefore, is whether the guarantee is violated if the goods subjected to levy of entry tax are not produced or manufactured within the state levying the tax. Our answer is in the negative. This is because there is no question of any discrimination if goods from outside the state are not at a disadvantage vis-a-vis goods produced or manufactured within the state. It is true that a levy on goods that are not produced or manufactured in the state is likely to make such goods costlier, but that is not enough for the levy to be considered unconstitutional. A responsive government aware of the needs of its constituents will be under tremendous pressure to keep such taxes low enough for its constituents to be able to afford the same. Democratic processes and pressures within the system of governance that we have will take care of any aberration in this regard. What is absolutely clear, however, is that Article 301 will not frown upon such a levy simply because same or similar goods are taxed and are not produced or manufactured in the state. And they then went on to say that states are well within their right to design their fiscal legislation to ensure that the tax burden on goods imported from other states would fall within the state equally. And that's important to understand how commerce has played itself out in India. And those were 6 points that I made from the decision in Jindal Steel. What was the 7th point? Because the matter didn't end there. There was an entire concept of goods which were imported from outside of India and whether they could be taxed by states, because otherwise import and export is a matter of federal policy. And the 9-judge bench decided to leave that question open, which only got answered separately in a separate decision which came out a couple of months later by a 2-judge bench of the Supreme Court. And this became critical again because the level and the quantification of taxes that we were looking at was extremely large. So, for example, if you were in a landlocked state like Rajasthan and all your imports had to come to ports, there could be Paradip in Orissa, there could be Kandla in Gujarat, there could be Vishakhapatnam in Andhra Pradesh, wherever it was, the state like Rajasthan could impose an entry tax because effectively after the goods landed in the port, they had to be transported by road or by rail into the state. And when this matter came up before the Supreme Court took a very, very expansive view of the whole constitution. And they said in a decision in 2019 called State of Kerala versus William Fernandez that the matter was not about whether goods were coming from one state or the other. The Supreme Court said it is a well-known rule of statutory interpretation that by process of interpreting the provisions, the words expression any place has to be widely read, and it could not be read restrictively. Now, why is all of this important? All of this is important because it explains to you the quasi-federal character of India. The reason why it becomes further relevant now is because you've now sought to move away from the regime and you've moved into what is the GST regime. Because the GST regime is really about the economic unity of India. And it comes back to the part of Atyabari that I had read out to you earlier, where the Supreme Court had cautioned and said, we've won our political freedoms, but we need economic unity. And literally after 70 years of our independence, did we come out with the GST regime, which brings about to a large extent a single broad-based, single comprehensive tax system, which is levied at every point, and it's levied by the states and it's levied by the union, but it is a single comprehensive regime, which works well within the economic unity of India. And that could only come about because of an amendment to the Constitution of India, which was the insertion of Article 246A. And in particular, 246A subclause 2 set out that in relation to interstate trade, the power of levy would be the parliament. So what does all of this show you? What is your takeaway from topic 1? Topic 1, my takeaway would be the economic unity, and 2 would be in relation to taxes not being a restriction to trade and commerce. That's the constitutional recognition of the federal structure of India and taxes. And that plays an important part in the manner in which we think about commerce and how it stands to be protected. Let me now move on to topic 2. And topic 2 is all about equality. And what I propose to do at the end of topic 2 is leave you with 5 takeaways. Because equality, as we all know, is enshrined in Article 14 of the Constitution, which sets out that the state shall not deny to any person equality before the law or the equal protection of law within the territory of India. So what does all of this have to do with commerce? Well, the answer is that it has a lot, because state action has to be fair, has to be reasonable, has to be non-discriminatory, has to be transparent, has to be non-capricious, unbiased, without favoritism or nepotism, in promotion of healthy competition and equitable treatment. And I can guarantee you that I have borrowed the last couple of sentences from a book that I have read somewhere. But what I have not borrowed and what I have not picked up is a formulation that I follow with. And that is that commerce in any country requires stability and certainty. And the law and the policy of the state needs to comply with Article 14 if it has to ensure stability and certainty. Let me just give you one brief example about policy and how it needs to comply with Article 14 before I discuss 2 other broad aspects. Okay, so policy, as we all know, is formulated by the government through regulations, which are often conferred on the basis of a statute. let's take the example that I want to give you is a very practical example. All of us are fully aware and frustrated with with call drops that happen on our mobile phones. I mean, frankly, when I'm on a mobile phone at the most critical juncture of a conversation, the call will just drop. And this really takes me back to the old age problems that all of us used to have, or a lot of us probably here in the seminar used to have at the time when we had landline telephones and those dialing mechanisms where calls would get disconnected and there would be no dial tone, and you'd effectively have to pick up your phone again 15 minutes later to look whether there was a dial tone and then dial the number again. Well, that in the mobile telephone age, frankly, that was unexpected, but when it did start happening, well, the government came out with a regulation, and that was a regulation in 2015. The government came out with a regulation called the Telecom Consumers Protection 9th Amendment Regulation, under which every originating service provider who provided cellular mobile telephony was made liable to credit the calling customer ₹1 for every call drop which took place within its network, up to a maximum of 3 call drops a day. So if you do simple math, if it's ₹3 a day and it's 30 rupees a month, sorry, it's in 30 days in a month, you're looking at 90 rupees, which could potentially go back as a credit into the hands of every customer. And that, when you multiply with the number of customers, becomes a potentially colossal amount. And naturally, all of this ended up before the Supreme Court. And while the Supreme Court did not go into the factual controversy, it struck down the impugn regulation on the ground that it violated the service provider's rights under Article 14. And one of the reasons which the Supreme Court cited at paragraph 69 of their decision, which I will quote, was the following. It said, "We have already seen that the impugn regulation dated 16/10/2015, which was to come into force only on 1/1/2016. We have been shown a technical paper issued by the same authority on 13/11/2015, a few days after the impugn regulation, in which the authority has itself recognized that 36.9% of the call drops take place because of the fault at the consumer's end. Instead of having a relook at the problem in light of the technical paper, the authority has gone ahead with the impugn regulation, which states that the said regulation has been brought into force because of the deficiency of services by service providers leading to call drops. The very basis of this statement contained in the explanatory memorandum to the impugn regulation is found by the self-same authority to be incorrect only a few days after publishing the impugn regulation. This itself shows the manifest arbitrariness on the part of TRAI, which has not bothered to have a relook at the problem. For all the aforesaid reasons, we find the impugn regulation is manifestly arbitrary and therefore violative of Article 14. It is an unreasonable restriction on the right of the appellant's fundamental rights under 19(1)(g) to carry on business and is therefore struck down. And this makes the point, which is the certainty that commerce needs. And the regulations that are framed require a level of certainty where the right hand needs to know what the left hand is doing, which is often a problem that you will find in government. Keeping that as the introductory part to the equality issue under Article 14, I want to now deal with two broad aspects. The first relates to Article 14 and the constitutionality of certain commercial statutes. And the second part that I want to deal with relates to Article 14 and government contracts. Now, let's look at statutes first. And one of the biggest statutes, one of the most important statutes that has effectively been on the hit list in the last couple of years has been the Insolvency and Bankruptcy Code of 2016. We all call it the IBC. And I know for a fact that at least in Gujarat, and there have been a number of cases and a lot of high-profile cases related to the IBC, SR Steel, and the resolution plan of 42,000 crores by ArcelorMittal, I think was one of the largest IBC cases, which was there at NCLT Ahmedabad. And we know that the IBC is a statute whose main purpose is to protect the corporate debtor through a time-bound resolution plan so that it effectively protects the industry of finance. I put all of this into what I call the category of credit management statutes. So after the IBC came out in 2016, I mean, it is not surprising that there were a number of challenges that were made to strike down some parts of or the other of the IBC. They were done both on Article 14 as well as on Article 19. But the IBC wasn't the first, and it certainly won't be the last, in the category of credit management statutes, whose constitutionality has been questioned before the Supreme Court. So before I go into the 2019 decision in Swiss Ribbons, which relates to the IBC, I want to go back a couple of years to the decision of the Supreme Court in 2004 in a case called Mardia Chemicals, which dealt with the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, which all of us know is the SARFAC. Now, the main contention challenging the virees of the SARFAC was that it gave the banks and the financial institutions arbitrary power without any guidelines for their exercise, and also without providing any appropriate or adequate mechanism to decide disputes relating to the correctness of the demand, its validity, and the actual amount of dues that were sought to be recovered. And the offending provisions under the Act, it was said, were a one-sided affair because there were very drastic measures that could be taken onto the property of a person who was a defaulter. Now, it's very, very important to remember that these actions were brought into the court by people who had defaulted on their obligations. They had taken financing and they had failed to repay. Now, while the constitutionality of the SARFAC was upheld in Mardia Chemicals, because the court said that there was nothing draconian about it, despite whatever averments had been made by the debtors, one part of it was struck down. And that was Section 17, which required every defaulter to deposit 75% of the demand at the initiation of any challenge proceedings. And the Supreme Court considered that to be arbitrary, because even in, unlike civil cases, where if a court ordered an attachment before judgment, it only did so after hearing the parties. And the Supreme Court took the view that the requirement of the deposit of 75% of the demanded amount was unreasonable, arbitrary, and violative of Article 14, because it was imposed while approaching the adjudicating authority of the first instance. There was no determination of the amount due, which could be made at the time of the deposit. The secured assets or their management is already under the control of the creditors, and the borrowers would be left without a remedy if the borrower was unable to raise 75% of an undetermined demand. And the approach of the Supreme Court was one to protect rights. It was balancing rights between the creditor and the debtor, and it took the view that the debtor's rights could not be taken away. Now, if you fast forward all of this 15 years later and move on from the SARFAC to the decision of the Supreme Court in Swiss Ribbons, you again see a balancing of rights between the debtors and the creditors. But it goes a step further. It balances rights in what it calls a very intelligible differential, which I agree with, between the rights of financial creditors and operational creditors. And as I will take you through that judgment, I'm going to tell you that Swiss Ribbons is an extremely pragmatic judgment because it recognizes the reality of commerce. And the reality of commerce is that while on the one hand you have people who finance, on the other hand you have people who trade. And while both these categories of people may become creditors of a company, there is a distinction between them. And there is a distinction with a difference. So I'm going to quote some parts of the judgment in Swiss Ribbons, which I think are relevant to make this point. At paragraph 37 of Swiss Ribbons, the Supreme Court reiterated what we all know is a very integral part of Article 14, which is the principle of intelligible differentia. And it said the test for violation of Article 14 of the Constitution of India when legislation is challenged as being violative of the principles of equality have been settled by this court time and again. Since equality is only among equals, no discrimination results if the court can be shown that there is an intelligible differentia which separates two kinds of creditors, so long as there is some rational relation between the creditors so differentiated with the object sought to be achieved by the legislation. This aspect of Article 14 has been laid down in judgments too numerous to cite from the very inception. And then the court rejected what was a very simplistic argument, and that was to club the interests of financial creditors and operational creditors into the same bucket on the basis that they were both owed monies by the company. And the court said the following. It said, according to us, it is clear that most financial creditors, particularly banks and financial institutions, are secured creditors, whereas most operational creditors are unsecured, payment for goods and services as well as payments to workmen, not being secured by mortgage documents and the like. The distinction between secured and unsecured creditors is a distinction which is obtained since the earliest of the Companies Act, both in the United Kingdom and in this country. Apart from the above, the nature of the loan agreements with financial creditors is different from contracts with operational creditors for supplying goods and services. Financial creditors generally lend finance on a term loan of a working capital that enables the corporate debtor to either set up or operate its business. On the other hand, contracts with operational creditors are relatable to supply of goods and services in the operation of businesses. Financial contracts generally involve large sums of money. By way of contrast, operational creditors have dues whose quantum is generally less. In the running of a business, operational creditors can be so many as opposed to financial creditors who lend finance for the setting up of or working of a business. Also, financial creditors have specified repayment schedules and defaults entitle financial creditors to recall a loan in totality. Contracts with operational creditors do not have any such stipulation. Also, the forum in which dispute resolution takes place is completely different. Contracts with operational creditors can and do have arbitration clauses, whereas dispute resolution is done privately. Operational debt also tends to be recurring in nature, and the possibility of genuine disputes in case of operational debt is much higher when compared to financial debt. A simple example will suffice. Goods that are supplied may be substandard, services that are provided may be substandard, goods may not have been supplied at all. All these operational debts are matters to be proved in arbitration or in the courts of law. On the other hand, financial debts made to banks and financial institutions are well documented, and defaults made are also easily verifiable. Most importantly, financial creditors are from the very beginning involved with assessing the viability of corporate debtors. They can and therefore do engage in restructuring of loans as well as reorganization of the corporate debtors' business when there is financial stress, which are things operational creditors do not and cannot do. Thus, preserving the corporate debtor as a going concern while ensuring maximum revenue for all creditors being the objective of the court, financial creditors are clearly different from operational creditors, and therefore there is obviously an intelligible differentia between the two, which has a direct relation to the object sought to be achieved by the court. And this logic is absolutely correct, because it is financial creditors who inject the finances into the economy, and they have to be treated differently from operational creditors from the aspects of insolvency proceedings. Giving them greater or higher rights is the correct thing to do, because otherwise insolvency management will go for a toss. And it was necessary for the court to have recognized this distinction, even though it caused a fair amount of heartburn to the operational creditors, who effectively at the end of the day get little or nothing of the pie if the corporate debtor goes into liquidation. And in fact, let me just quote again from the Supreme Court and just tell you what it said. It said, it will be seen that the reason for differentiating between financial debts which are secure and operational debts which are unsecured is in the relative importance of the two types of debts when it comes to the objects sought to be achieved by the Insolvency Code. We have already seen that repayment of financial debts infuses capital into the economy inasmuch as banks and financial institutions are able, with the money that has been paid to them, to further lend such monies to other entrepreneurs for their businesses. This rationale creates an intelligible differentiator between financial debts and operational debts, which are unsecured, which is directly related to the objects sought to be achieved by the code. And again, I make this point because when you look at the pragmatic approach the Supreme Court takes, it takes it from the perspective of protecting the larger economic good of the country. Because it cannot be second guessed that banks and financial institutions in this country are the backbone for its economic prosperity. Now, where does all of this take me to? Well, it gets me to the last part of this subtopic under Article 14. And I'm going to now spin it back into the judgment of Hindustan Construction, to which I had made a reference when I was just after I'd spoken about Vodafone. And again, it shows the Supreme Court's understanding of the reality of commerce in India. And this is now in relation to arbitrations. And the fact of the matter is that the reality of arbitration and the insidious problem that we've always had is, and I'm going to quote what Fali Nariman once said. Fali Nariman said, arbitration was the first step to litigation. And people got arbitral awards, and then the litigation in court in relation to those arbitral awards went on for years at an end before they could recover the money. Now, at one stage, the government tried to put a stop to that. And they did that by the 2015 amendments to the Arbitration Act. But for some reason, they sought to deviate from that policy in 2019, when they brought in Section 87 in relation to certain arbitrations where they said that the new progressive amendments would not apply. There was effectively a partial break that had been put. And naturally, for all the parties who had succeeded in arbitrations, who were extremely happy with the 2015 amendments and the manner in which the Supreme Court had interpreted it in a judgment called BCCI Kochi, they were suddenly put in a predicament where they could not enjoy the fruits of their award. At the other level, because you now had an IBC in place, despite the fact that they had awards in their favor, they were getting sued left, right, and center in the NCLT because IBC proceedings were beginning against them. So they decided to challenge the 2019 amendments on the ground that there was no need for an automatic stay of an arbitral award just because a challenge had been filed. And the Supreme Court agreed with them in HCC, and it set out a paragraph 57 as follows. And it said, also, it is important to notice that the Sri Krishna Committee did not refer to the provisions of the Insolvency Code. After the advent of the Insolvency Code in 1/12/2016, the consequences of applying Section 87 is that due to the automatic stay doctrine laid down by judgments of this court, which have only been reversed today by the present judgment, the award holder may become insolvent by defaulting on its obligations to its suppliers when such payments would be forthcoming from arbitral awards in cases where there is no stay, or even in cases where there are conditional stays. Also, an arbitral award holder is deprived of the fruits of its award, which is usually obtained after several years of litigating as a result of the automatic stay, whereas it would be faced with immediate payment to its operational creditors, which payments may not be forthcoming due to monies not being released on account of automatic stays of arbitral award, exposing such award holders to the rigors of the Insolvency Code. For these reasons, the deletion of Section 26 of the 2015 Amendment Act, together with the insertion of 87 of the Arbitration Act by the 2019 Amendment, is struck down as being manifestly arbitrary under Article 14 of the Constitution of India. So that, in a nutshell, covers my first topic under Article 14 in relation to statutes. And there are 4 takeaways that I have from here. The 5th takeaway I will, under Article 14, I will deal with when I deal with contracts. And the 4 takeaways are this. 1, the highest constitutional court in India, and again, high courts across all states understand the realities of commerce. Two, courts do not permit impositions through regulations that are arbitrary or illogical. Three, if there is an intelligible differentia in the commercial sense, then they will uphold that intelligible differentia, even if there is a case or an empathetic case to be made out because if it's inconsistent for the greater sake of the economy, then that empathetic case would just have to give way. And four, even in commercial matters related to the state, they will not allow an unreasonable imposition which hampers a party's right to approach a forum. And you saw that in the Sarpesi cases. I can also promise you that the rest of what I'm going to talk about is going to be considerably shorter. I now move on to the second subtopic under Article 14, which deals with contracts. And for that, I'm going to take you now to look at Article 298 of the Constitution, under which the union and the state have been given the power to enter into contracts. And Article 298 says, the executive power of the union and of each state shall extend to the carrying on of any trade or business and to the acquisition, holding, and disposal of property and the making of contracts for any purpose. Sorry, if you just excuse me. Now, in reality, we know that states enter into contracts not directly, but what we loosely call state instrumentalities. They enter into contracts with organizations and we loosely call them state instrumentalities. And the reason for calling these entities state instrumentalities is so that we get protected under Article 12 of the Constitution. And I'm going to make a reference to Patel Engineering, where the Supreme Court said in relation to the National Highways Authority that while the National Highway Authority enters into contract, it does not do it under Article 298. But that doesn't mean that the National Highways Authority is not an instrumentality of the state under Article 12. Now, I'm not going to go into Article 12 and greater details about Article 12. I'm sure most of you have know about it because you are all practicing lawyers with enough practicing lawyers in the High Court where you invoke the writ jurisdiction under Article 226 and 227. But the point I want to make is that because they're state instrumentalities, they cannot take arbitrary action. My focus here is going to be on really what are on tenders and not on general contract or commercial tenders, because you've got the well-known judgment in Tata Cellular, which deals with that, which clearly again says that the state cannot act arbitrarily in relation to the awarding of tenders. But really, in a place where the Supreme Court has decided to heighten the extent of judicial scrutiny, and that is the case which involves natural resources. And for that, I make a reference to the decision of the Supreme Court in what was a special presidential reference in the natural resources allocation case, which you will find in 2012, 10 SCC 1. And that arose from a presidential reference on a limited point of whether auctions, which we all know are probably the most logical way of awarding tenders, would be the only option when it came to the alienation of natural resources. Now, I'll give you the answer that the Supreme Court gave later, okay? And I'll give that to you when I deal with commercialism. But the point I want to make is this. When the Supreme Court was dealing with that case, and it was dealing with trade and commerce in relation to natural resources, and we're talking about mining, we're talking about petroleum, all of these are massive resources that lead to large contracts. The Supreme Court said the following, and it said, what was brought in was the doctrine of public trust and trusteeship. And they said, as far as trusteeship is concerned, there is no cavil that the state holds all natural resources as a trustee of the public and must deal with them in a manner that is consistent with the nature of such trust. It then went on to say, and again I'm going to quote, it said, when the affirmative duties are set out from a obligatory angle, the doctrine does not exactly prohibit the alienation of properties held as public trusts, but mandates a high degree of judicial scrutiny. And again, go back to a point which I had made very early on, which I'd taken from Gadboy. You may have various governments that continue coming in. You may take various policy decisions. But when you juxtapose that with the umbrella organization, which is a judicial organization, the Supreme Court, you will see that it's been the sheet anchor to protecting our democracy and protecting our rights. And again, this is an exposition of what the Supreme Court believes it needs to do. And for that reason, it becomes extremely important that while a state is allowed to exploit natural resources commercially, must so act on principles of Article 14. And that is the fifth takeaway, because if it doesn't do so, then the court will exercise a heightened degree of scrutiny in looking at the state's actions. This now moves me on to Article 19. And I deal with this more from the perspective of trade and restrictions. Now, not surprisingly, the talk has to be based on Article 19(1)(g), which we all know grants to citizens of India the right to practice any profession or to carry out occupation, trade, or business. But again, as all of us know, the right comes with reasonable restrictions in general public interest. And I'm going to focus on two facets of the right to trade. The first, the first facet that I want to talk about is the doctrine of res extra commercium. And res extra commercium, as we all know, is that what is immoral cannot be treated as commerce. And again, not surprisingly, alcohol in India is treated as immoral. So even if it, for a number of states, except Gujarat, Bihar, constitutes a large part of their taxing revenue, it does not grant people a fundamental right to carry out that trade. But what is res extra commercium is something that you need to look at from the perspective of a society that is dynamic. And I don't say that, the Supreme Court does. And I want to quote to you from a recent decision, because at one level, if alcohol is res extra commercium, non-obscene dancing is not. And the Supreme Court said that in a decision, and I'm going to quote from, there have been a couple of decisions on dances and dance bars, but the reason why I want to quote from a 2019 decision is because it talks about the social dynamism of res extra commercium. And this is the case in Indian hotels versus the state of Maharashtra. And at paragraph 79, the court said, it needs to be borne in mind that there may be certain activities which the society perceives as immoral per se. It may include gambling, and then they put a bracket saying, though that is now becoming a very debatable issue, prostitution. Fortunately, there's no bracket there. It is also to be noted that standards of morality in a society change with the passage of time. A particular activity which was treated as immoral a few decades ago may not be so now. Societal norms keep changing. Social change is of two types, continuous or evolutionary, or discontinuous or revolutionary. The most common form of change is continuous. This day-to-day incremental change is a subtle but dynamic factor in social analysis. It cannot be denied that dance performances in dignified forms are socially acceptable and nobody takes exception to the same. On the other hand, obscenity is treated as immoral. Therefore, obscene dance performances may not be acceptable and the state can pass a law prohibiting obscene dances. However, a practice which may not be immoral by societal standards cannot be thrusted upon the society as immoral by the state with its own notions of morality and thereby exercise social control. And again, the reason why this is important is because when you're looking at imposing restrictions, you have to bear in mind social norms. And social norms and a change in social norms lead to a different appreciation of the nature of restrictions which can be imposed. Now, whether this is ever going to lead to a state where whether we will ever legalize marijuana, I don't know. I don't think so. I don't think that's ever going to happen. But this is just, again, an aspect which shows you that the court is very dynamic in its thinking and approach. Now, the other aspect of Article 19, apart from res extra commercium, that I want to talk about, relates to the imposition of reasonable restrictions and the entire doctrine of proportionality. And I want to pick it up again from a recent case. It's a case which Anshin had mentioned a short while ago, which was a cryptocurrency case. Now, we all know that the Supreme Court very rarely interferes with economic regulations, especially if it's been formulated by the Reserve Bank of India, but it did so in the cryptocurrency case. We also know that cryptocurrency is something that is absolutely fraught with risks. And while it can lead to a lot of gains, it can also lead to a lot of losses. It is speculative, and I think that's something that all of us have to accept. And people need to be educated, and those who do so, and despite that education, decide to trade in cryptocurrency, are doing it at their own risk. Let me give you an example of how fraught cryptocurrency is by simply referring to the first paragraph of a recent decision of the Singapore Court of Appeal on cryptocurrency. And the Singapore Court of Appeal, which is its highest court, began its decision by saying the following. It said, the world of cryptocurrency trading is not for the faint-hearted. Now, cryptocurrency, which claims to be an alternative form by which trade can take place, is something which the state is absolutely unhappy about. And this is not just the state in India, it's the state all over the world, because if most states consider it as an affront to fiat money, to sovereign currency. But does that mean that you completely ban it? Because along with cryptocurrency, there are a number of other aspects that are brought in. One, innovation. Why do I say that? Cryptocurrency came out on the basis of a platform called blockchain technology. And today, the platform of blockchain technology has revolutionized the online banking world. It's revolutionized the concept of digital money to the extent that every government recognizes that blockchain technology is the one way to go in relation to paperless digital money, even if it is offered by the sovereign state. And when I say every state, that includes the Reserve Bank of India. And there are a lot of documentation in relation to that. Two, apart from innovation, anything that is technological brings about entrepreneurship. Three, technology is disruption, but if disruption doesn't arise, change doesn't happen. 20 years ago, we all discarded emails. Today, emails is the most important form of communication. Video conferencing, we're doing all of this today. That's all happened because of technology and disruption. And if you were to put the curbs on that, you're effectively putting curbs on other fundamental aspects of the economy. Now, what the RBI circular did was that it effectively disallowed banks from dealing with anybody who wanted to deal with cryptocurrency. So even though there was no legislative ban on cryptocurrency, even though cryptocurrency hadn't been declared to be res extra commercium, the RBI circular effectively meant that trading in cryptocurrency could not be done using formal banking channels. And for cryptocurrency exchanges who wanted to follow formal banking channels, who were perfectly happy with regulations, that meant the end of the business. And the argument that was made before the court was that it was an unreasonable restriction under 19(6) because it was not proportionate, The RBI's concerns of terrorism financing, so on and so forth, were not made out simply because formal banking channels were used, because somebody could still continue buying cryptocurrency with a bag of cash. And the Supreme Court said the following, and I'm going to quote from paragraph 212, and it said, there can be no quarrel with the proposition that banking channels provide the lifeline of any business, trade, or profession. This is especially so in light of the restrictions on cash transactions contained in section so-and-so of the Income Tax Act. When currency itself has undergone a metamorphosis over the centuries from stone to metal to paperless, and we have ushered into the digital age, cashless transactions, not penniless transactions, require banking channels. Therefore, the moment a person is deprived of the facility of operating a bank account, the lifeline of his trade or business is severed, resulting in trade or business getting automatically shut down. Hence, the burden of showing that larger public interest warrants such a serious restriction bordering on prohibition is heavily on the Reserve Bank of India. And then based on that, it went on to hold at paragraph 241 that it is no doubt true that the RBI has very wide powers, not only in view of the statutory scheme of the three enactments indicated earlier, but also in view of the special place and role that it has in the economy of the country. These powers can be exercised both in the form of preventive as well as curative measures, but the availability of the power is different from the manner and extent to which it can be exercised. While we have recognized elsewhere in this order the power of the RBI to take a preemptive action, we are testing in this part of the order the proportionality of such measure, for determination of which RBI needs to show at least some semblance of any damage suffered by its regulated entities. But there is none. When the consistent stand of the RBI is that they have not banned virtual currencies, and when the government of India is unable to take a call despite several committees coming up with several proposals, including 2 draft bills, both of which advocated exactly opposite positions, it is not possible for us to hold that the impugned measure is proportionate. So what is the takeaway from the discussion under Article 19 and reasonable restrictions? 1, trade and commerce has to fall within societal norms which are dynamic, and courts recognize it. 2, courts do not shy away from striking down government action if it imposes an undue restriction on trade and commerce. And 3, and this is important, courts recognize that even if the state is unhappy with some form of technological measures, unless the state decides that it wants to declare it as res extra commercium or legislatively ban it, it needs to ensure that innovation, entrepreneurship, democracy, and growth are very important for a democratic society to flourish. And it cannot just have one organ of the government deciding that it wants to knock off something that may turn out to be great in the future. This now gets me to a very short topic, and I can tell you that the rest of the topics become shorter, and that deals with private contracts. And as far as private contracts are concerned, well, we all know that writ remedies and constitutional remedies don't really exist in private contracts. But what do I want to talk about here? Well, I want to talk about the concept of whether private contracts can fall into the sphere of public functions. Now, this doctrine of public functions was first brought about in a decision of the Supreme Court in 1979. It's a famous R.D. Shetty decision. It related to the airports. And what the Supreme Court said is that it may be noted that besides the so-called traditional functions, the modern state operates a multitude of public enterprises and discharges a host of other functions. If the functions of the corporation are of public importance and closely related to governmental functions, it would be a relevant factor in classifying the corporation as an instrumentality and agency of the state. And then they use that doctrine to go a step further in the decision related to cricket and the Board of Control, the BCCI. And they basically said in the BCCI decision that given how important cricket was to the nation, the functions of the board were clearly public functions. And they said the following, the Supreme Court said the following in the BCCI decision. It said, the function of the boards are clearly public functions which till such time the state intervenes to take over the same remain in the nature of public functions, no matter discharged by a society registered under the Registration of Societies Act. Suffice it to state that if the government not only allows an autonomous private body to discharge functions which it could in law take over or regulate, but even lends assistance to such non-governmental bodies to take such functions which by their nature are public functions, it cannot be said that the functions are not public functions or that the entity discharging the same is not answerable on the standards generally applicable to judicial review of state action. And the reason why this becomes important in relation to this is because today what you're faced with are services that are being offered by companies such as WhatsApp and Facebook. And these services are effectively private agreements that are being signed by individuals along with the companies that operate these services. And a lot of privacy rights are given away. But to turn around and say that they don't exercise a public function, which is of communication, which today effectively is necessary in the world that we're living in, is going to be very hard. Now, I don't want to make a comment on what the Supreme Court is going to do with WhatsApp. I don't want to conflict myself out of these cases. But the question that is going to arise before the Supreme Court is whether the general public which enters into these contracts, which are non-negotiable, the contracts of addition, will entitle the state to regulate, will entitle them to be regulated by the state or by the courts in the manner in which public functionaries are considered because of the nature of services they offer. It's an important question, and that's going to arise in the future. But let me just leave my views on that here, because I don't want to get conflicted out of any position. And now that gets me to the last part, which is commercialism. So how does commercialism fall into all of this? Now, as I mentioned to you earlier, the difference between commerce and commercialism is the following. Commercialism is commerce at any cost, with only a profit motive. Now, as far as education is concerned, we know that the Supreme Court frowns upon education as a matter of commerce. It frowns upon it more when it considers it as commercialism. And in fact, in the 2011 decision, the Supreme Court said the following. It said, in the post-constitutional era, an attempt has been made to create an egalitarian society, removing disparity amongst individuals. After independence, there has been an earnest effort to bring education out of commercialism. Now, the reason why I make a reference to this is because you will consistently see the approach of the court in ensuring that commercialism is not permitted in our Constitution. And I'm going to go back to the last quotation that I have for the day, and that is, again, for the natural resources cases. This is the presidential reference in natural resources, where I told you I would give you the answer on whether an auction was the only method by which by which natural resources could be allocated by the state to private parties, and the Supreme Court said no. And the reason why the Supreme Court said no was the following. It says, in conclusion, the submission that the mandate of Article 14 is that any disposal of natural resources for commercial use must be for revenue maximization, i.e. commercialism, and thus by auction is based neither on law nor on logic. There is no constitutional imperative in the matter of economic policies. Article 14 does not predefine any economic policy as a constitutional mandate. Economic logic establishes that alienation allocation of natural resources to the highest bidder may not necessarily be the only way to subserve the public good, and at times may run counter to public good. Hence, it needs little emphasis that disposal of all natural resources through auctions is clearly not a constitutional mandate. And clearly, you can see behind the Supreme Court's approach that commercialism is an activity generated only for profit, which is going to get little support from the court. And that is because commercialism will go against the grain of our constitution. Profit cannot be made at any cost, even by the government which allocates these natural resources. So that now really brings me to the conclusion. And I mean, I must thank all of you for sitting through this lecture that I have given. I've given you a lot of takeaways from the different positions that I have. And I am going to conclude by where I started, which is, well, you have a constitution whose preamble says that it is by the people, for the people. And normally, and even for this lecture, I had a quotation. Sorry, I'm going to give you the last quotation from Sirvai. And this was from Sirvai on constitutional law. And I actually scratched that quotation out earlier this morning, because while I was on the internet looking at some other stuff, I found an interview that which was done by Mr. Sirvai's son, Navroz Sirvai, on an article on Bar and Bench. And I found a very apt statement that Navroz made. And let me just quote you from Navroz as opposed to the great Mr. Sirvai, because not that Navroz is not great. Navroz is a great senior advocate in Bombay. And I'm going to give you a quotation of what Navroz said. And he says the following. And he says, so the next time I would request all lawyers, you refer to this right, which is constitutional right, be careful how you describe it. It is not given by the Constitution, let alone any government in power or any charismatic leader. You always had this right, and the Constitution merely recognizes it and secures it for you. Ladies and gentlemen, again, thank you very much for sitting through this lecture. And thank you to the organizers for giving me an opportunity for addressing everybody on the topic of constitutionality of commerce and commercialism. Thank you.
Thank you, Mr. Dewan. We had a really good session full of content. Maybe we can do a quick 2 or 3 questions that we have. Possibly they hinge between a query and a thought, mainly related to what we encounter here in Gujarat. So the first question is, in terms of what you said vis-a-vis constitution and commercialism, we have something called the Fee Regulatory Committee here in Gujarat, where there is a legislation which has been introduced which restricts schools, private schools, which do not take government grants from charging or rather they decide, the committee decides on what a school should charge. Completely dehorse what a person who's ready to take and a person who's ready to accept are willing to say. For example, the school is willing to take 100 rupees. I am ready to pay 100 rupees. The government comes and says that no, you can only charge 40 rupees. How do you deal with such a situation?
Education in India has always been a very difficult sector from the perspective of how it's viewed. Education, unlike in the West, which is viewed as literally a trade and commerce industry, is not viewed in India like that. Education is something which otherwise the state is required to provide, which I think the state hasn't done its due share, and that's required private players to enter the field. The concern that the government has on a constitutional level is simply that if you let educational institutions charge whatever fees they want to charge, it will become a trade and industry. And to avoid that, they've set up all these fee regulation committees. And it's not just in Gujarat, it's done in a number of states where private institutions haven't taken any grant from the government. They still believe it needs to be controlled because that's the way you impart education across India, to be able to increase the level of education. I think what is important in my view is this. If people know and are fully aware that that's how education is treated in India, then they know whether they want to enter into the field of education or they don't. And if people who are only interested in pure commerce and pure profit don't think it's the place they want to go to, then they shouldn't.
A second interesting query we have is, while we have a ban on alcohol in Gujarat, there is no ban on cigarettes, there is no ban on any other vices. What is the yardstick of what should be banned and what should not be banned? Because both hinge on the aspect of morality, but how do you determine which is less evil and which is not?
So the question is, I mean, legislatively, you can make something less extra commercial, right? Which is effectively based on state norms. I mean, the reason why you've got a ban on alcohol is a state policy decision, but you also have a directive principle in our constitution which says that you should actually try and ensure that India is a liquor-free country. Now, that has not been implemented by every state. Effectively, I think morals are something which society decides. And if a particular society decides that it wants to be smoke-free, then great. I mean, if the legislature can implement it, it's good for them.
One last question in relation to what we are facing today. Whether an order, direction or advisory passed by the government of India compelling employers to pay wages, would it not be violative of the Constitution?
I do have some views on that, but I'm going to be very careful because well, the matter was filed in the Supreme Court last week, and the Supreme Court has not even issued notice on it. My reading of it is that the MHA orders go beyond the powers under both the statutes that are in operation right now. And there is a credible argument to be made that because they go beyond the power, they have no force of law. So, I mean, leave the rational argument aside. So that's my view on the matter. I can't say any more because it's really a sub judice issue. But I mean, I would not be surprised if more parties decided to challenge it because, again, from an economic reality perspective, it is impossible for many industries to continue paying people when they're not able to generate revenue. There are some companies which are cash rich. There are some companies which have reserves. They may be able to take this as a short blip. But what happens to a company where there is just no money? Because what are the two options you face? You either face the option of being prosecuted by not complying with the order by the labor commissioner, or alternatively, if you pay and you go bankrupt, then that's the end of the matter. How do you revive your company? So it's really you're in a difficult position, and I think people will be compelled to challenge the MHA order.
Thank you so much, Mr. Dewan, for sparing time for all of us. We've had a fantastic session today. On behalf of all the office bearers and all the members of all the associations, a big thank you to you. We'll see all of you tomorrow at 4 o'clock. We have Honorable Ms. Justice Harsha Devani who will be giving us a perspective of the judiciary in terms of what is expected from us lawyers. So see you all tomorrow, and thank you so much, Mr. Dewan.
Thank you very much. Thank you.
Thank you, sir.
Thank you, sir.